Criminal law. Non-fatal offences against the person. Common assault. Section 39 of the Criminal Justice Act 1988 states that assault is a summary offence and has a maximum sentence of 6 months. The offence of assault has no statutory definition and it remains a common law offence with the definition and all elements of the offence set out in case law. The definition of assault is found in Fagan v. Metropolitan Police Commissioner, 1969. Mr. Justice James in the Divisional Court set the definition of assault as, an assault is committed where the defendant, intentionally or recklessly, causes the victim to apprehend immediate unlawful personal violence. The actus reus of assault consists of 1. The conduct of the defendant. 2. Causation. 3. The victim must apprehend. 4. Immediate. 5. Unlawful personal violence. 1. The conduct of the defendant. The actions of the defendant must cause the victim to apprehend immediate unlawful personal violence. Assault cannot be committed by an omission. Examples of conduct amounting to an assault would be pulling a punch, brandishing a knife, pointing a gun or throwing something at the victim. It's important to note that no physical contact is required for an assault. Any contact or touching would amount to battery or if an injury was inflicted either ABH, GBH or wounding. Most batteries would also involve an assault. So for example, before a punch is landed, the victim will generally apprehend the violence that is then immediately applied. It is only where the victim is taken unawares or attacked from behind that there would be no assault. Originally, it was thought that actions rather than words could amount to an assault. In R.V. Mead and Belt, 1823, the defendants were not liable when they sang threatening songs outside the victim's house. In R.V. Wilson, 1955, it was stated, obiter dicta, that words could amount to an assault. In R.V. Constanza, 1997, Lord Justice Sheeman in the Court of Appeal departed from R.V. Mead and Belt, holding that conduct accompanying words can make the words an assault. Words can also be used to negate an assault. In Tuberville v. Savage, 1669, the defendant put his hand on his sword and stated, "If it were not assize time, I would not take such language from you." Assize time is when the judges are in town. Whilst the act of taking his sword would normally constitute an assault, reference to the assize time indicated he was not going to resort to violence, so no assault had been committed. In R.V. Ireland, the House of Lords went further and held that silence can amount to an assault in the context of silent telephone calls. It is clear from R.V. Arabica that simply looking at someone is not sufficient for an assault. 2. Causation. Assault is a result crime. Therefore, causation must be established. This means the prosecution must demonstrate that it was the action of the defendant which caused the victim's apprehension of unlawful personal violence. The principles of factual and legal causation apply. Please see separate video entitled, Causation in Criminal Law, for further details. 3. Apprehend. The victim need not be put in fear but must be aware that they are about to be subjected to violence. If the victim does not anticipate unlawful personal violence, there is no assault. In R.V. Lamb, 1967, the defendant was not liable for constructive manslaughter, as no assault had been committed. This was because the victim did not believe the gun would go off. Conversely, according to Logden v. DPP, where the victim apprehends immediate unlawful personal violence, an assault will be committed even if there was no actual threat of violence. 4. Immediate. Threats of future violence will not amount to an assault. Smith and Hogan's Criminal Law, 4th edition, page 351 states, there can be no assault if it is obvious to the complainant the defendant is unable to carry out his threat, as where D shakes his fist at P who is safely locked inside his car. However, the courts have adopted a more liberal approach to the requirement of immediacy. In R.V. Ireland it was held that with regards to psychiatric injury the violence was immediately applied to the mind when the victim picked up the phone. In R.V. Constanza, Lord Justice Sheeman held that a person receiving a threatening letter could perceive immediate unlawful personal violence. In Smith v. Chief Constable of Woking, Lord Justice Kerr rejected an argument by the defendant that there could be no immediacy as he was outside the house, whereas the victim was locked inside. 5. Unlawful personal violence. If the defendant has a lawful excuse to use force, the actions will not amount to an assault. This includes reasonable punishment of a child under Section 58 of the Children Act 2004, where the victim consents, or where the defendant acts in self-defense or prevention of a crime. The term personal violence can be misleading, in that the victim need only apprehend the level of force that amounts to a technical battery. That is, any physical contact will suffice no matter how slight. The mens rea of assault. According to MPC v. Fagan, the mens rea of assault is intention to cause the victim to apprehend immediate unlawful personal violence, or being reckless as to whether such apprehension is caused. The case of R.V. Parmenter established that the subjective Cunningham recklessness applies to all non-fatal offences against the person requiring recklessness. Therefore, the defendant must foresee a risk that the victim would apprehend immediate unlawful personal violence. In summary, assault is a summary offense with a maximum penalty of 6 months imprisonment. Contrary to popular belief, no physical contact is required. An assault is where the defendant intentionally or recklessly causes the victim to apprehend immediate unlawful personal violence. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.